immigrationquestion.com, your go-to resource for U.S. immigration insights.
Hello, everyone, and welcome
to
this special edition webinar hosted by
your
Immigration
go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to this special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is Samia Murat, and I will be your host for today's important discussion. VAWA Self-Petitions in 2026. New evidence requirements you must know. For immigrants experiencing abuse by a U.S. citizen or a green card holding family member, the Violence Against Women Act, or more commonly known as VAWA, may provide an opportunity to seek immigration relief independently and confidentially. However, preparing a strong VAWA self-petition requires careful documentation and a thorough understanding of current evidence expectations. As adjudication trends evolve, applicants and advocates may pay closer attention to what types of evidence USCIS finds most persuasive and how to present a well-supported argument. To help break this down, we are honored to be joined by Irene Vaisman, Esquire, an experienced immigration attorney who assists individuals pursuing humanitarian immigration relief, including VAWA self-petitions and related immigration matters. Attorney Vaisman, thank you for joining us today. We're thrilled to have you for this important discussion.
My pleasure.
Before we begin, just a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared with you all today is for general information purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, on YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding VAWA self-petitions and evidence requirements. Now we're going to dive into the questions. To begin with, I want to ask, can you explain the purpose of a VAWA self-petition and who do you think may qualify under this form of immigration relief?
So, hello everybody. My name is Irene Vaisman, as said, and I am an immigration attorney with 21 years of practice. So, VAWA, okay, it is an act. It's a congressional act that was enacted by Congress, and it thankfully continues to be reauthorized. So don't be fooled by the name, even though it translates into Violence Against Women Act. It's not only for women, it applies to men just as it applies to women. And so immigrants who are men, women, whose spouses are U.S. citizens and are abusive, whose spouses are green card holders and are abusive, and whose parents are either green card holders or U.S. citizens and are abusive, may qualify for under this act, okay? And it is basically a pathway to your green card without the need to rely for that family member. And let me quickly explain the difference between your parent or spouse being a green card holder and a U.S. citizen. When they're a U.S. citizen, meaning that visa is available and you can simultaneously apply for adjustment of status for a green card if there are no disqualifying aspects to that adjustment of status. And obviously that would need to be determined by an attorney when that attorney conducts your consultation. And if your spouse or parent is an LPR, meaning a green card holder, then you fall into a priority category. And currently there is some waiting time for visas to become available, which means that you cannot adjust your status or receive your green card simultaneously, and you'd have to wait for that priority date to become current.
Okay. And what are the core elements USCIS looks for when reviewing a self-petition?
Okay, so the way I like to describe it to my clients, when they come in for consultation, there's three elements to a VAWA case. Okay, the first one is proof of abuse. Okay, so abuse can be different. VAWA cases can be different. It can be physical harm when a physical harm was inflicted, or it can be emotional. Oftentimes, it's a hybrid of both when a person suffered both psychological harm, emotional harm, and actual physical harm. But there are definitely cases where there has been no physical harm and it's just emotional harm. Those are more difficult cases, and the evidentiary standard is higher, and it's a different standard. But that's your one aspect, okay? The proof of abuse. The second one is proof of relationship. You have to have proof that that there is a qualifying relationship, okay, between you and the abuser. And the third aspect of this is good moral character. So you have to show that you are a person of good moral character. Just very quickly what that means, because the other, well, they're not so self-explanatory, but I'll explain the good moral character one. If you have been arrested for for anything, you got to provide a disposition. You have to show if you resided in more than one state in the United States. I recommend getting an FBI like background check, because it will show that you have not been arrested or in trouble anywhere. Okay, and if you only resided in one state, you can just get the police report from that one state, but I still prefer to go with that FBI background check because I think it's more comprehensive. And of course, if you have been arrested, then you have to provide the disposition, and then you would really need to explain away what happened, no matter how minor it is. There are, of course, other ways to show good moral character, but that's primarily what they're looking for.
Okay. And then can you also just go into or explain any other credible evidence standard and how USCIS applies it in these cases?
So there's actually law on this. And oftentimes when people, when you submit the petition and you submit some evidence, sometimes people will receive, and sometimes people don't always have good evidence, right? Especially the psychological cases, right? So when you have a physical case, you may have a police report. And of course, that's your best evidence, right?
Right.
Police report, hospital records, if you've been in the hospital, and both combined, they are amazing evidence. But you may have photographs, right, of your injuries. But you don't always have that. And remember, in the psychological cases, there have been plenty of cases where the abuser got rid of the evidence, right? They they are hiding the evidence, they're hiding the documents. It's part of the abuse. So you rely on circumstantial evidence, affidavits from people with knowledge, okay? Maybe there can be different types of evidence that is circumstantial, that would still show what you're trying to prove, when we lack direct evidence. And there is case law on point that says that this is actually has to be looked at in the light favorable to you, the applicant, because when initially they enacted this, they understood that you, the applicant, may not necessarily have that evidence of because of the abuse in reality. So, and it's always very important for us to remind USCIS of this standard, okay, and how they have to view the evidence.
Okay. And what types of evidence are currently viewed as the most persuasive to prove one's claim?
As I said, I mean, obviously your best evidence is police reports,
Right.
medical records. Um, I personally think that psychological records are really important, especially when there is psychological abuse. So I do work with psychologists or social workers to show that in fact there has been abuse. If a person is in a shelter, okay, they have
Okay.
fled the family home and they're in the shelter, and letter from that shelter. Usually, also the shelters will have their own social workers, and a person would be working with that social worker. So a letter from them would be very useful. Orders of protection. If you sought an order of protection and then it was extended, that if your abusive spouse is not allowing you to see your child,
Mhm.
okay, um, the documents from family court then would become really important. If you have photos from abuse and social media, if you have text messages, save all those things. If you have they left you nasty voice messages, so we can't, even though we can't submit video evidence to immigration, there are ways to um, turn that video evidence into screenshots, okay,
Okay.
and have it transcribed to show what happened. Okay, that's direct evidence, and that's always going to be the best evidence.
Okay. And how important is the applicant's personal declaration in a
Personal
self-petition?
declaration is very important. Okay,
Okay.
you really need to put the time and the thought into your personal declaration. You really need to pour your heart out. Okay, and actually, doing this quite often, I also feel that in a way it helps the person to get all their feelings out.
Mm.
It's often very difficult for them to talk about some of the things that may have happened to them, and some of the abuse is horrific, really. But put it all on paper,
Okay.
details, okay, and then we can go through it. But affidavit is really important, and then obviously we can put events. If you have evidence to support it, then we can put together what you wrote in your statement with the evidence and present it to USCIS. But personal statement, very important.
Okay. And I'm just interested to know what's your final advice that you would give an applicant preparing for a self-petition in today's immigration environment?
Okay, so as you know, this is going to come no secret. We are living in a very difficult immigration environment.
Mhm.
So everything is difficult right now. VAWA cases have always been difficult, okay? But current environment is different. And let me actually also give you some new things that are happening with VAWA cases right now that we didn't necessarily have before. So if you simultaneously submit your VAWA application with your green card application, they did indicate that they could call you in for an interview. Historically, there have never been interviews on the actual VAWA petition. That has always been adjudicated on paper.
Oh,
But right now, if you submit that I-360, which is the form that you use for the VAWA, together with your green card application, they could call you in for an interview. Okay, what could be the benefit of submitting those two together? You receive employment authorization. Okay, and then if you don't have a social with your employment authorization, you can get your social. Okay, so that's definitely a benefit. And most people choose to do that. Otherwise, the processing time for the VAWA application is more than 2 years. It's between 2 and 3 years, very long. And people wait for all those years without employment authorization. It's very difficult. But sometimes people don't submit that green card application for different reasons. Again, every case is different, but just be aware that if you simultaneously submit it the I-360, which is the VAWA application, and the green card application, you could be called in for that actual, not the green card interview. I mean, there will be the green card interview, but that actual VAWA interview where the officer will ask you about the abuse and your life with your abuser. Okay, so that's something that is new. Another thing that something to pay attention to is you really have to prove that you resided with your abuser. Okay, you have to show that you resided during the marriage with your abuser. How do you do that? Income taxes, lease, joint utility bills, um, joint bank account statements, joint documents. Okay, so just like basically think of the types of documents that you would show that to show the bona fide nature of the marriage. These are the same types of documents. Also keep in mind that if you have a lot of pictures together, pictures alone do not show that you have actually resided together. So while they will show that your abuser and there was a relationship, pictures can show quite a bit. They don't necessarily show that you resided together. Okay, so keep that in mind. A lease and income taxes and bank account statements used by both parties, that's your better evidence. Utility statements, better evidence to show that you have resided together, with your abuser. Hire an attorney. Okay, I understand that some people say, well, I don't have the money or whatever. So there are organizations out there. Each state has organizations, pro bono organizations. Some law school do this. There's low bono organizations. And then if they really don't have the for, to be their client, then they usually have a list of trusted attorneys that they refer you to. And you can go there, but it's very important right now to have an attorney, because unfortunately what has been happening is if there is a denial, your case is going to get referred to immigration court. Okay, and that's another new trend. Okay, that's been happening. Also previously, if a VAWA was approved, USCIS would issue something called deferred action, where they basically wouldn't initiate removal proceedings against you if a green card application was not filed at the same time and not approved. They don't do that anymore, really. So very important to get it right the first time around and present a good case. So you really should do it with an attorney.
Thank you. Thank you for those insights. For everybody watching, this discussion about VAWA self-petitions is not to create fear or confusion, but rather to clarify how applicants can better prepare and understand the process. Stronger documentation and credible evidence, like mentioned by Attorney Vaisman, can make an important difference in presenting a well-supported petition. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're proud to share that ImmigrationQuestion.com is BBB accredited and also ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Attorney Vaisman, based on your experience assisting with VAWA applicants, how does ImmigrationQuestion.com help immigrants as well as immigration attorneys like yourself?
Well, I mean, you can spread the word, right? You can get the word out. And I like what you said. This is not to create fear, by no means. And another thing is, it's just a lot of, again, I don't want to say women, but a lot of people that are victims of abuse, the true victims of abuse, they're already really scared. And they think that, again, part of the abuse is the abuser would say, without me, you're nothing. Without me, you can't get your documents. I'm going to, give your name out to ICE, right? And especially right now, when we're living in a climate of fear, it puts even more fear into the mind of the victim. So I think that a forum like this where you have an information session is really the purpose is to provide people with knowledge.
Yes.
A, don't be scared. B, there is something that can be done. C, if you are a victim, a true victim of abuse, you don't need your abuser to, to get help, to get your documents, to get legalized, okay? So this is to spread knowledge, not fear.
Thank you. Now, before we move into our live Q&A, let's tackle this very important question. What is one common misconceptions applicants have about these self-petitions that you believe should be clarified before they can embark on this process?
Misconception about VAWA. Well, unfortunately, there has been a lot of misuse with VAWAs. So, and there's a lot of notario fraud, I would say. So, people who are unlicensed, who if somebody promised you something and something just doesn't sound right, or it's not true, it sounds too good, okay, get a second opinion, okay? Make sure you're working with somebody who is licensed. It's always good to get a second opinion right now with, forums such as Immigration Question, or, other materials available out there. Although, some of the materials available out there is, a lot of it is just wrong, but unfortunately, but just don't get fooled, okay? Use, you're a smart person, you can figure things out. Just think, don't sign blank forms, don't sign anything that's blank. Always review everything that you sign. Just understand that, yes, there is a pathway if you've been abused, but review everything, okay? And if a fact didn't happen, but somebody's telling you, oh, just put it down, don't do it. That's fraud, fake, you don't want to do that, okay? So just if you're a true victim of abuse, whether it's physical or psychological or both, okay, speak to a qualified immigration attorney who can walk you through this the right way, okay? And you can get this done the right way.
Thank you. If you're just joining us, we're speaking with attorney Irene Vaisman on VAWA Self-Petitions in 2026, new evidence requirements that you must know. We're now moving into our live Q&A session. This is your opportunity to ask general questions, and also hear educational insight from a licensed immigration attorney. Please drop your questions in the chat or call us live at 516-703-3483, and we will take as many questions as the time allows. Okay. Question. Is emotional or psychological abuse enough to qualify for a self-petition, even if there is no physical violence?
Yes, it is, okay, but the burden of proof is higher, okay? So these are, these cases are more challenging, okay, but absolutely done those cases. It's just more difficult.
Okay.
And you have to be more careful with your evidence and your personal statement.
Okay. Question number 2. Does receiving a request for evidence on my VAWA case mean USCIS is planning to deny my petition?
Absolutely not, okay? But it does mean that whoever has reviewed it thinks, there's not enough and they want to see more, okay? Sometimes it's fair, sometimes it's unfair, okay? It's possible to receive a request for evidence for, a very well-documented case. Also, every request for evidence is different, okay? It could be a request for evidence for, say, good moral character, right? For, they didn't think they had something. Actually, once I think I've had something like this, wherein we provided the FBI prints, and they still sent it to us. So we did it one more time. We provided income taxes, we provided letter from employer, and other, and it was approved after like 2 weeks. So every request for evidence is different. But no, it doesn't mean they're going to deny. But if you did this by yourself and you received an RFE, go see an attorney, show this to them. Also advice to, whoever, I don't know why you would do this by yourself, but let's say you did. Very important, please keep a hard copy of everything you have submitted to USCIS. Keep an electronic copy, keep a hard copy, okay? Very important, because then you can show it to the attorney, and then in the context of the RFE, we can point out that, guys, well, this was submitted. You seem to be, ignoring this important
Right.
evidence that was submitted.
Okay. What evidence does USCIS actually want to see in a self-petition package in 2026?
Okay, so again, the way I do it, I always have like a very well drafted cover letter. And remember those three things that I spoke about in the beginning. We have evidence of abuse, we have evidence of of the bona fide nature of the marriage, and then we have the good moral character stuff. Okay, so put your evidence, and then you'll have the actual forms, right? The actual application. So that's how you would present your case. I seem to have lost my host. Okay, so feel free to put through more questions if you have questions, and I will answer them. I will answer them as they come. And again, if we're talking about evidence, just really separate it all out in your cover letter, list everything you're sending, and just be very specific. Try to show them exactly what you're sending. If there has been physical abuse in the case, then show that physical abuse, right? Show photos, show if you called the police reports, if you've gone to the doctor. If you went to the doctor, provide those medical records, right, to USCIS. If there's social media evidence, put that in there, okay? But make sure that it's visible where it's coming from. So if it's coming from Facebook, put it, so that they can see, the name of, the profile, the date where something was posted, so that there is trace. And same for Instagram or any other social media accounts. If there are messages that have been left on your phone, if there are emails that were, if they were sent to you, then absolutely provide that. Let's see, next question. Can I still qualify for VAWA if I do not have police reports, medical records, or other official documents? Yes, you may, okay? Again, I don't know what kind of abuse you may have suffered, but it doesn't matter, right? Or as long as there was abuse, it could have been psychological abuse. So you can, it just, speak to an attorney as to the types of evidence you do have. And again, you may have that circumstantial evidence available. You may not have the police reports because you were too scared to go to the police, right? Or maybe there was no physical evidence. But yes, you can still qualify for VAWA if there was abuse. Okay. how do I prove my marriage was real if I do not have joint lease, bank accounts, or utility bills? Circumstantial evidence. Okay, you would prove it with circumstantial evidence. We would look for other documents to show that you and your abuser resided together. The types of evidence, I don't know what you may have, right? But we would really need to look into your specific case to see. But of course, it could be, it could be more difficult. And your personal statement would need to be a lot more detailed, and you would need to show um, why you may not have those documents. It's usually part of the abuse, okay? But it just depends. So
Recent reports indicate that USCIS has partially lifted the asylum processing freeze for applicants from certain lower risk countries. So, Attorney Weisman, I want to know, when asylum seekers hear about this partial lifting of the processing freeze, how should they interpret these developments, such as like concerning interview scheduling and priority processing?
okay, so they've conducted the interviews during the freeze on the decisions. It was just a freeze on the issuance of adjudications, okay? But interviews were conducted. So sometime this past fall, USCIS did indicate that they would pause the adjudication of affirmative asylum cases, not the defensive. The difference between affirmative and defensive: affirmative is with USCIS, defensive is with immigration court. So the freeze was with the affirmative cases. They have now lifted that, and it's not for low risk countries, it's actually for everybody. What does it mean? That all those people that had their interviews and their decisions are pending, you may start seeing those decisions start coming in, okay? You may not, okay? They may still be, some decisions do take longer, okay? I mean, I have seen the asylum office take more than a year, sometimes more than 2 years to actually adjudicate a case. On occasion, there is a repeat interview that can happen too. It shouldn't, but there could. It just depends on circumstances. But and I am seeing decisions are starting to come in, and it's either an approval, right? Congratulations, or it's a referral to the immigration court. And what's been happening with that is that there is a directive. So this is really recent. This is like this week, okay? So there's a lot of changes in immigration law. So we have like every week something is happening. It's either from the BIA or some secret memo or some other directive. But it's been interesting. So there is a directive that says to try to push cases through, and they are trying to schedule that first time on cases to go on as fast as possible. Many people are not represented. They went to that affirmative interview by themselves, and now they find themselves with that notice to appear, and they need to be in immigration court and at a master calendar hearing, which is the initial hearing. You need an attorney, period. Okay, you can't miss that hearing. If you miss that hearing, there is going to be an in absentia order of removal, so you can't miss that hearing. Oftentimes, the actual date of the hearing and what you have on that notice to appear, it's going to be a different date. So, you really need to monitor the court date, through other means other than what is stated on that paper, unfortunately. I'll tell you even more, we as attorneys, often recently, find new cases are on our calendar, like our cases have been moved up without notice. So, I mean, I log into my court account several times a week just to make sure that I haven't missed anything, because sometimes these things happen without notice. So you really got to be on top of things. And this is especially true with, like, if you change your address, please make sure that they have, the correct address. And by the way, with VAWAs, when you submit that application, they do give you a chance to provide them with a safe address. Okay, so always very important for you to have the correct address with immigration on file. It's
Thank you
also
to
known, and it's always been an application.
Sorry. Thank you.
Okay.
Thank you to everyone who joined us for this special webinar. And thank you, Attorney Vaisman, for sharing your knowledge and your practical guidance. You can always visit immigrationquestion.com to ask immigration related questions, to stay informed about politics and policy updates, and also know about any upcoming live events that we may have. If you missed any part of today's discussion, the replay will be on Spotify soon. Search Borderless Talk by immigrationquestion.com. We look forward to seeing you next Wednesday at our next live session. Stay informed, stay prepared, and stay connected. Thank you.
Bye, everybody.